I think now is 7:03, and we can start because today we will have four presenters from all over the world, from India, from United States, from the Netherlands, Ireland. So let's get started. And our first presenter is from India, Professor Kashidi, and he's from the University of Delhi. And Kashidi, the floor is yours, and you can start when you're ready.
Okay, thank you so much. Uh, so you will be moving the PPTs for me? Oh,
Yes,
okay,
our colleague Jessica will help you with that.
okay, okay. So thank you so much for giving me that opportunity. And the topic of my presentation is very much aligned to whatever I'm engaged with right now. That is regulation of AI and genetics in Global South. And the problems are a little peculiar in Global South as compared to Global North. And that is why we need to decipher that what are those situations which are needed to be addressed. So can I have first slide? The first second you can skip, and then I will come. The third one. Okay. Yes. So how AI is being applied to genetics and what kind of challenges it is being posing, that is something which needs to ponder, because both the fields are evolving fields and the laws relating to both the fields are still in making. So the first impression which AI creates on human genetics is that it creates a lot of possibility for tailored medicine, personalized medicine, biomedical research, diagnostic tools, so on and so forth. So there are various promises which could be translated into benefits in Global South. And I mean, in that way, it is a kind of progress which we are seeing. But along with that, it also poses numerous risks. The risks which were already attached with human genetics in the form of genetic discrimination, genetic inequity, they are being amplified by AI. Second, next one. So AI, the previous one. Yes. So the AI, I mean, it's being used for risk modeling, and it is being, used by the insurers, employers, and because of that, it is intensifying the genetic risk, predictive genetic risk, which could be automated and which could be, based on complex algorithms, and that may create a situation which is highly complex as compared to the previous situation. Next. So one of the main aspect of AI is that it has a built-in bias. So if it is not being properly trained and it is not inclusive, in that way it may be underrepresented and it may have bias which has been there in many of the countries in Global South which had colonial legacy. So they may be carrying the same bias in the AI also if it is not being rectified. So that is something which is just multiplying the things in a more, you can say, rapid manner. Next. So what is the relevance of AI and genetics or human genetics in Global South? So as I mentioned earlier, it has great promises in diagnostics. It has great promise in precision medicine. And it may also be providing tools, as we have seen in the COVID phase, that there were so many, aspects of AI into medicine, which has been very helpful. So in that way, it is creating a lot of promise. Next. Next one. Yeah. So the previous one. So these are the potential barriers which are there. Number one is colonial legacies, as I mentioned earlier. Then systemic inequalities. Even if we are making the genetic data sets diverse, we are more inclusive. Even then, whether that is reaching to the people who are really requiring it, that is something which is still needed to be addressed. So systemic inequalities are deep rooted and they need something beyond the mere equality or mere discrimination, process. Then we have in Global South uneven digital infrastructure. And the third one is the complex, the matrix, which the countries in Global South are facing. They are facing a kind of trilemma, not a dilemma, of protecting human rights, then fostering essential innovation and competitiveness, and then maintaining technological sovereignty. So the rhetoric which has been created by the technological companies, which are very much in the AI domain, they are making this thing, making this assertion that this is a kind of, development which is always needed. And because of that rhetoric, every country wishes to make some sort of, adjustment with regard to AI and genetics. Next. So one of the aspects is data colonialism and genomic extraction in Global South, which is very much apparent, which has been in practice for a long time. So in today's world, MNCs or the tech companies, they are a crucial player, and they are also into the governance of this very AI and genetics. So in that way, they are targeting data-driven health solutions in Global South without repaying them what they extract from it. So that is something which creates a concern for equity. Next. And these countries face dual risk of dependency and exploitation because they have underfunded local innovation system. They are highly reliant on external partnerships and various other modalities in the form of IP, drug discovery, know-how. They are also aligning more in the technology-driven, countries. So, despite contributing immensely, they are not being, able to reap the benefit what they contribute. Next. So, one of the potential arguments which has been made is diversity and inclusion must be made in genomics so that the genomic data sets may not be faulty, they may be more inclusive, and they may cater the need of the global population. But as I said, that because of the systemic biases, because of the systemic, kind of discrepancies, it is not being made, viable. Next. So now the question is how to tailor your law, how to tailor your ethical guideline, whether you should just adapt what is being going on in any other country, or there is a need for contextualization of those laws or even ethical guidelines which are being made. So whether global South countries may go for risk-based approach as it is being classified for European Union, or sectoral model of United States, or innovation-friendly framework of UK, that is offering something, but it is not really, catering the need of these countries because the situation is a little different. Next. So the first dilemma is how to balance global integration of the AI and genetics rules and norms, and how to maintain the national autonomy. So that is something which these countries are needed to address. And because of some common concerns, there is a need of harmonization of these regulations too. But if you just go by the specific provisions, that may create a kind of regulatory divergence and it may lead to regulatory arbitrage. So what kind of regulation and what kind of approach these countries need? This is a thing which need more research. And there are certain countries which are going for proactive smart regulation, which is giving more flexibility for the self-regulation along with various kind of players which are involved in it. Next. So if you see the current legal response or regulatory response of few of the countries which I have highlighted, you may see that they are varying in their approaches. So if you see the Brazil, it is very much classifying the sensitive data, and if you see Peru, it has come up with the AI regulation or law. which is more, you can say, aligned to the smart regulation, but the institutional support is still missing to that. Next. In South Africa, it is very much vocal. The law is very much vocal against the automated decision making, but the other aspects are there which are in the form of challenge. If we take Nigeria, it has implicitly sensitive, you can say, personal data classification, not explicit. Next. When it comes to India, we do have data protection law, but that data protection law again does not classify what is sensitive information and what is non-sensitive information. And in Bangladesh, it was reported that genetic discrimination happened without a notice or without a realization, and that has been documented also. So they came up with the national AI strategy, but when it comes to the data protection laws or AI laws, they are missing both. Next. So the thing is that when we talk about the regulation of AI and genetics, whether this genetic discrimination and genetic inequity, is it you can say real risk or it is a potential risk? So as I mentioned that there are cases which has been reported, they are not in big numbers, but still they are there, which are reported where it has been clearly demonstrated that genetic discrimination is happening on the basis of insurance, on the basis of employment, and it has been also in one of the cases which has been highlighted in Delhi High Court too. Next. So if we talk about the viability or the necessity of specific legislation, if that legislation is missing, then what kind of impact it generates, like what kind of impact this regulatory gap will generate. So it has one impact, that is the regulatory mechanisms remain ill-equipped. Next, due to fear of genetic discrimination, even for medical necessity, people may not approach for genomic test or genetic test. Sorry. So meaning thereby, there are a kind of stigmatization in the absence of law, which may create a kind of protective model where people may take that very recourse. So laws and technologies in case of AI and genetics, because both are evolving field, they sometimes outpace the law. So there are certain void which are still being there. Next, if you see the de-identification and re-identification problem. So suppose there are countries which, if the data is de-identified, they allow that it is permissible for the research. But if you make that thing permissible without any consent, then again, through the AI technologies, there is a risk of re-identification. And whether for the re-identification, you need that very specific consent, on that very point, there are some gaps in the law. Next. Next. So this I have already explained to you. So how much time I have? 5 minutes or something?
You still have, yeah, by 6 minutes.
Okay. So this I have already mentioned that if the AI is not trained with the proper, you can say, inclusive setup, then it may lead to disparities and systemic bias, and that may intensify the genetic bias also. Next. Next one. So whether human rights approach could guide this very lawmaking or ethical guidelines and all that. So human rights, because they are this conjunction of AI and genetics is impacting the human rights in a most serious way. That is why human rights can guide the lawmaking. It can also guide the ethical rules. So if you see human rights through its two key, declarations maintain that human genome must be considered as a common heritage to the mankind. Then again, if you come just previous slide. Yeah. So it is clearly mentioning that no one shall be subjected to discrimination based on genetic characteristics that is intended or has the effect of infringing human rights. Next, if you say International Declaration on Human Genetic Data, it again mandates efforts to prevent genetic and proteomic data from being used for discrimination or stigmatizing purposes. But because, as I mentioned, that one of the main player in today's world in the domain of AI and genetics is the multinational companies. So how you provide a guidance to those companies so that they can come up with a more robust framework. So one of the attempts have been made by the United Nations Human Rights Council, which endorsed the guiding principles on the business and human rights. Next. So it creates a kind of setup where baseline responsibility is being fixed. You need to provide mechanisms, you need to provide protection where you must respect the basic human rights. Next. So this very guiding principle is based on protect, respect, and remedy. So meaning thereby, these companies must carve out the strategies which may implement all the three, provide basic respect to the human rights, as well as they can provide the remedies. Next. So how this thing could be triggered at the international level, because we are talking about the global south. So the initiatives must either be taken by the regional forces, or you can say global south countries, or it could also be flagged by the international organizations. So when it comes to the international organization, they are also making normative influences. If you see the UNESCO's recommendation, that is also paying heed to that. And WHO is also advocating for the hard law, and it asked for a robust regulation of the large multimodal. So, meaning thereby, these organizations are still influencing the lawmaking. So, they have this very responsibility to trigger this thing for the benefit of these countries which are not in the mainstream. Next. So, but what is happening? I mean, these bodies, may it be UNESCO, may it be WHO, their recommendations are not being translated in a robust, specific legal framework. And that is something which is missing. And this is because of the high economic status involved in this very, terrain. Because of that, big tech companies, they maneuver that very thing, and the countries are not being able to properly regulate this very affair. So I'm just stopping it or concluding it by mentioning that this regulatory conundrum or regulatory dilemma which has been there for global south countries, how they could be rectified, or how they could proceed with that very regulatory regime. So my point of view is that all, may it be soft law, may it be hard law, both has some role to play. So when it comes to you know uh, inequity, when it comes to inclusiveness, this could be promoted through soft law also. We need ethical guidelines, we need many things in that very boat. But when it comes to genetic discrimination, which sometimes go unnoticed, in that very terrain, I think that there is a need of a specific, robust law or legal framework that could deal with the various aspects of genetics, even if it is being touching base with the AI. Thank you very much.
Thank you. Very wonderful presentation and so informative. Any questions? Oh, questions? Prince, please.
Hi. Yes. Thank you so much. Very, very interesting presentation. Yesterday, some of the themes that came up in Professor Rothstein's presentation was about the genetic exceptionalism. And so I think it's so interesting looking at both the AI regulation and law and genetics law. And I was wondering what you thought about merging them together versus having two separate laws addressing the issues, and how we could think about incorporating genetics really from square one into AI regulation sort of explicitly, or do you need to do that explicitly? Can it be done? So just thinking about sort of genetic exceptionalism versus AI exceptionalism and how we go forward as these get more complex, as you so rightly mentioned.
Okay, so my point of view is that because this very conjunction is creating a kind of challenge which is so unique, and it could not be dealt by just making legislation for AI. So to me, if you are making some sort of, you can say, provisions or some sort of, you can say, inclusion within the genetic law framework, that would be more effective, because many countries, if I remember correctly, don't have specific genetic anti-discrimination laws. I mean, there are so many countries in global south. So I think that this is something which is not discussed in mainstream that much as AI as such is discussed. So given the peculiarity, you need to incorporate a specific provision within the genetic laws, I mean genetic discrimination laws, anti-genetic discrimination laws, rather than creating two different kind of sets for that. So that is something.
So thank you for your answers. And who will have more questions?
Perhaps I can ask a question, Song?
Yeah, absolutely, please.
Good. So Kshitij, I was wondering, one development that we've seen in genomics, and I'm not sure up to what point it was successful or not, has been the development of the concept of benefit sharing. And I mean, as a theory, it's quite interesting. And I think in at least the Indigenous Population Forum, that has kind of help towards, a more equitable, even though there are still ways to go, especially in my country, framework. And I was just curious if you were aware of whether benefit sharing is gaining some traction as a context in the forum of AI, to palliate some of the inequities that we see there between developed and developing countries. I was wondering if that was something you had looked into a little bit.
Yeah, I think there are certain case studies in India too where benefit sharing is being provided, but not in genetics particularly. So I mean,
I'm more curious about AI actually in the context of benefit sharing, because I do know about it in genetic, but I was wondering if you see it on the topic of AI as something that is discussed as a context and that is starting to surface in the regulations.
thus far I'm not aware of anything, I mean, like that which has been, in discussion or something, or it has been. It may be that I might slipped it, but as far as my knowledge is concerned, benefit sharing in AI domain is not discussed that much. I mean, I'm not aware, at least.
All right. Well,
So,
that's very interesting. Maybe it's something that could be pushed in that direction
and
because I
in
mean
line
AI
with that,
depends on data as well.
Mhm.
in line with that, if I will just, yeah, if you, yes, now if you talk about the data, then uh, still it is in flux. I don't think that there is a very clear stand of that it should be backed by benefit sharing. The other point is, which I have just gone through some of the scientists' discussion. They were, making this very argument that once we take the human genome or human, genomics as a public good, global public good, then in that very case, if we allow benefit sharing, whether we are not, inviting some sort of, you can say, trouble to the very concept of global public good or not. So that is another version of debate which is going on, vis-a-vis the benefit sharing. So these are, I think, very transitional times. So I think that it may settle in few years or something.
Thank you.
Yes.
Thank you. So we will have Talia.
Yeah,
Talia, yeah.
yeah. Thank you for the very interesting talk. The question I'm raising is actually for all of us at GDO. It seems there's a recurrent concern of the soft laws and soft regulations and zero applicability or zero accountability. So I wonder if we need to ponder writing a white paper about that with strong recommendation for accountability. This is open to the floor, of course. Thank you.
Yeah, I think
I think
our director of GDO can respond to this question.
it's noted, Talia. We will have a discussion session a little bit later this morning or this afternoon for you. And I think that this would be a great topic to suggest for common work this year. So I'm definitely noting your idea and let's revisit it a little bit later today.
Thank you, Jan. Thank you.
I agree with Jan. I mean, that is something which we all are, discussing, that what should be the law or what should be the right way of approaching the things. If they are in transition, whether we should go by the soft law and then proceed with the hard law. So that is something which may be catchy to many audiences, I think. Yes.
Okay, so any more questions? Or we can turn to the next speaker. We'll go to our next speaker. Jessica, can you share the screen? Yes, perfect.
Yes.
So for our next speaker is Tanner Kuru. So he's from Netherlands and the Timburg Institute for Law, Technology and Society.
Yes. Hi, everyone. Good morning, good afternoon, good evening, wherever you are in the world. And yeah, this can also work for me. Like I can also say next for the next slide. So I wouldn't mind also sharing my screen. And if at one point it's more convenient for you, I can also switch to sharing my screen. So anyway, it was actually a really nice build up to my presentation because we just started talking about investigative genetic genealogy with the Golden State Killer. And thanks to Anya also, I don't need to explain the direct-to-customer genetic testing services now. So it took away some of the workload from me. And just to give you a bit of an background, I'm a PhD researcher at Tilburg University, and I'm a data protection lawyer. So my presentation is mostly from that perspective, and also from a bit criminal justice background. So and also with a bit of EU data protection focus. So if we can go to next slide, yeah, after the title slide, the second one, please. Yeah. Thank you so much. So before starting about what IGG, the investigative genetic genealogy is, let me maybe go through the, so to say, conventional methods in order to underline why it became such a groundbreaking tool, so to say, in the criminal justice world. Because normally in criminal investigations, we first have the direct comparisons, meaning that when you have the crime scene sample, then you can identify certain suspects or other individuals, and you compare those samples against each other. And that's the most conventional method since the DNA was sort of introduced to the criminal justice systems. And then we started storing these samples, and eventually we started having these databases where you can search the crime scene profile or the crime scene profile extracted from the crime scene sample against those stored in those databases. And those databases are normally populated nowadays with profiles from arrestees or suspects. It totally depends on the legislation of the jurisdiction, but most of the time it's arrestees and suspects whatsoever. And then we started using those databases in order to identify other people than those stored in the databases, and that we call familial searching. And it depends on the jurisdiction whether it's allowed or not. But then the first thing that you do there is that you search against the database, but you don't check for the full matches, but you look for, so to say, partial matches in order to identify the first degree relatives, so that you can see if your suspect, so to say, is, let's say, brother or the parent of someone in the database. And then recently, what we also had this new method, so to say, DNA phenotyping, where you can infer some information from the crime scene sample about the donor of that sample, where you can, for instance, like externally visible traits, or where they might be coming from ancestry-wise, etc. So to get a bit more investigatory information for that case to proceed. But what was happening is that sometimes this is not enough, even though we have these kind of tools in the criminal justice system, and even in jurisdictions where all of them are actually allowed, there are cases that do not go further and they stay closed. They stay, well, they can also be closed, but they stay cold. And then if we can go to the next slide, please. This news broke, so to say, in 2018 with the arrest of the Golden State Killer. And his arrest made its way to the international news headlines. It was not because it was just a big investigation, but it was because how it was caught, and it was revealed afterwards that he was actually identified through searches against GEDmatch, one of the genealogy databases. And then we started learning about this new technique that is being used by law enforcement authorities to identify criminal suspects. And let me go through a bit the workload of the investigative genetic genealogist, so you would have a bit more idea about what I'm talking about. So normally, as you can see in the first image, so to say, the icon, you have the crime scene sample, and you follow the conventional methods that I just mentioned, but it doesn't lead you anywhere. So you still have the suspect news, you didn't close the case. Then what you can do is that you can then extract an extra information. I'm not sure if you're familiar with the STRs and SNPs, but rather than STRs, you go for SNPs. And then that SNP profile is then being uploaded to one of the either directed customer genetic testing services, I'll explain in a bit, or genetic genealogy databases. Then you would try to identify the biological relatives of that suspect. And you may find, as you also mentioned in the previous talk, that sometimes relatives on the 6th or 4th degree, but it is still useful because then you can build those family trees in order to find the most common ancestor, and then start building that family tree down to identify your suspect. And if you're lucky, eventually you would find your suspect and your case will be closed. And if we can go to the next slide, please. Yes, but here I need to make a little bit of a caveat that my research and my talk is now focused on identification of criminal suspects, because you can follow the same workflow for unidentified human remains cases, meaning that, for instance, there is a part or a body has been found and you cannot identify the person, and then you can also use this same method. There's just one extra caveat here. Some of the unidentified human remains cases, such as baby doll cases, that may lead to criminal identification of criminal suspects. So that's a bit of a mixed zone in criminal suspect identifications and unidentified human remains cases. But in principle, I'm talking about only regarding the identification of criminal suspect cases. If we can go to next slide, please, then I will give you a bit of an overview of which databases are being used nowadays, because not all the databases are currently utilized for this purpose. And most importantly, for instance, those 23andMe and Ancestry, to the extent that we know, because this is criminal investigation and not everything is always transparent, but to the extent that we know, that they are not being utilized. But the top two databases, so to say, the first one is being GEDmatch, and it is actually not a direct customer genetic testing service provider, but it is a database that you can upload your test results obtained from different providers, so that you can actually see other biological relatives that you may have that are actually using other databases. And the second one is the Family Tree DNA, and that is a direct customer genetic testing service provider. And they also allow law enforcement searches in their database. But there are certain differences between GEDmatch and Family Tree DNA, apart from their characteristics. regarding like their database structure. The first one is that GEDmatch allows users to opt in for law enforcement searches. Of course, there are some like other nuances, but I'm just going to talk about like in a very like kind of a broad overview in their user schemes and like access schemes. And Family Tree DNA, they followed really different policies in different times. So you need to really check like what type of user you're talking about and like in what period you are checking. But in principle, they up until recently, they followed an opt-out policy. That means that if you wanted your data not to be used by law enforcement, then you had to actively opt out from law enforcement searches in their database. And GEDmatch they do not allow law enforcement searches directly to their database, but they operate a separate platform, which is called GEDmatch Pro. And Family Tree DNA allows law enforcement uploads based on a review process. So these are the private companies that allow law enforcement searches in their databases. But we have also two other, like one of them is also private, but two other databases that are a bit unique compared to GEDmatch and Family Tree DNA. And first one is DNA Souls, and that is operated by Opera exclusively for investigative genetic genealogy purposes, and they do not offer direct to customer genetic testing services. And as far as we know, that they have not been utilized so far by European law enforcement authorities, and they also run, sort of say, on crowdfunding scheme. And the other one is DNA Justice database, and it's a non-profit dedicated for IgG searches, but their number is relatively low, and as far as we know, they are also not been utilized by European law enforcement authorities. So this is, so to say, the overview of the databases that are utilized by law enforcement authorities. And if we can go to next slide, then I can give you a bit of an overview of which jurisdictions are using IgG currently. And the prominent user is, of course, the United States. And many of the law enforcement agencies across the United States are using actively IgG for both the criminal suspect cases and also for unidentified human remains cases. And there have been actually some laws passed, and if I'm not mistaken, it's like Maryland, Montana, and Utah, they have like explicit laws, but there are also some like indirect laws, and especially some of the laws that mentioned by Anya been interpreted in a way that may actually indirectly preventing IgG. So there were some calls about like maybe softening or like allowing some exceptions to allow investigative genetic genealogy explicitly on those states. And the second one, so to say, in this ranking is Canada. And Australia and New Zealand, they're also using it. And in New Zealand, it was, so to say, halted for a while, but the last news that I saw, it was actually allowed again. So I am not currently sure if it's again being operationalized or it was just like legal green light and still it has not been used. China is a bit of an interesting example there because there are a couple of articles out there that mentions that Chinese like IgG was utilized in China, but I cannot access to some of the like referred sources there. And sometimes, since this is a new method, the term is not really used properly because the method used, such as for instance using SNP profiles for criminal identification cases, are used as investigative genetic genealogy. So to that extent, I'm not quite sure whether it is really the case or not, but some articles mention IgG was used also in China. So this is the non-European overview, so to say, about the use of IgG in the globe. And if we can go to the next slide, I can give you a bit the overview in Europe. And in Europe, Sweden was the first one that utilized investigative genetic genealogy, and they closed actually the second biggest case in their history with it. And you can, if you're interested about it, apart from the Golden State Killer case, it is also becoming a bit famous. There's a Netflix series about it. Of course, it changed a lot of the facts, but it's still a good to watch to a bit like get information about that case. It is called The Breakthrough, and you can find it on Netflix. And Norway also used it for 3 cases and identified 2 of the criminal suspects in their cases. France has been using it, but I will also mention it in a bit, like in the overview, what are the developments there. There are some interesting things coming up from France in the near future. The Netherlands is currently using it for two cases. One is a criminal suspect case, one is an unidentified human remains case. But it's been, if I calculate correctly, like 2.5 years or a bit, maybe less or a bit more. But we still have no updates, and every time that we hear that, yeah, it's promising, but we still don't know what is happening with those cases, even though like parliamentary inquiries have been like passed about that. We still don't know what is the current status of those cases. And I will mention in a bit the Denmark, what is going on there. But what I wanted to mention about these 5 countries that you see a bit not like more glaring compared to the other ones, that they are using it for criminal identification of criminal suspect cases. The ones that you see below, apart from UK, that's there are not official information out there, but there are either scientific articles or presentations or news articles that are mentioned that unidentified human remains cases are being used for IgG. And UK, what I call is kind of like a Chekhov's gun at this point, because there are too many evaluations are going on. There is even an official report about should the UK use IgG or not, and there were some like legal sort of points were mentioned there before to be addressed before actually using this method in the UK. But especially for the unidentified human remains cases, we could expect UK to like utilize this method in the near future. But apart from UK, the other 3 have been definitely mentioned in either scientific articles or presentations in like the reputable conferences, like forensic conferences, or in the news outlets that it is being utilized for unidentified human remains cases. If we can go to the next one. Yes, thanks. So now, like I gave you a bit of the overview, both regarding globally and also a bit of the European focus, what is going on. So the issue is like why, despite the success, so to say, of IgG, it is a bit problematic from the legal sense and especially from the data protection perspective. And I'll also touch upon a bit the discrimination aspect of it. So the first one is a bit obvious, as Anya also mentioned in the other speakers in the previous part, that it's a form of police surveillance, because even though you are trying to identify the criminal suspect in this case, you are like inherently with this method, you are using other people's data that are not relevant to the criminal case, because normally like in a traditional or conventional criminal investigation, people that you touch upon as a law enforcement officer that are like somehow in vicinity of the crime scene. And it can be based on location, it can be based on association, but somehow it is relating to like criminal, the crime scene. But here it is like way beyond, like it is even like beyond borders of the crime scene. And that is a bit the challenging part regarding the police surveillance. And also one of the things that makes it a bit interesting regarding the legal sense is that these databases have been used as recreational sources. So just for hobby, like to learn about your ancestry or like to get some health-related information, but now they're being utilized for law enforcement purposes. So that is a bit changing the dynamic between the user and the company, because there's a new actor in this equation, which is the state or the law enforcement. The second one is also a bit touched upon, the issue with the consent, because one of the issues here is that consent is mostly used as a morally legitimizing ground by law enforcement authorities, especially in the US. And because it is, the rhetoric is that these people allowed their data to be used by law enforcement for such and such purposes, so it is legal for us to use it. But there have been some instances that this consent has not been exposed, actually. It's not been respected. For instance, it was exposed, like, if I'm not mistaken, it was 2023, and like mid 2023. The Intercept exposed that the genealogists were actually exploiting a quote unquote a loophole on JetMatch that was actually allowing access to genealogists to data that of users who thought they were actually opted out, but they were actually being utilized for law enforcement purposes. So these type of cases, and like there are other cases as well, but due to time considerations, I'm not going to mention all of them. So the using consent as a morally legitimizing ground is getting a bit under scrutiny. And also one of the issues regarding consent is inherent to the genetic data, because one person's consent affects, in a way, like the biological family members, and in this case, beyond even closely related biological relatives, because you can actually see cases that are solved through like cousins on the fifth degree and sometimes even beyond. So the population is like that is affected by this method is like really big in a way. And one aspect about the discrimination here is that the database composition, and I think it's maybe more relating to the US debate of it, or maybe to a certain extent, maybe Canada or Australia, and New Zealand, because the users of these databases are mostly from individuals of Northwestern European ancestry, and they are the most represented groups in these databases. And that means that these negative aspects, but also the positive aspects of like investigative genetic genealogy, like it can be case selection or like other aspects, are mostly affecting this population. So if you can go to the next slide, please. Yes. So my issue here is that how then we tackle these issues, because if we have like strong legal provisions that are like enforced and have the certain safeguards, then we can maybe prevent some of these issues. But unfortunately, in Europe so far, the situation is a bit scattered and fragmented. So for instance, in Sweden, they first relied on legal basis in the law enforcement directive, which for those who may not be familiar with, like in the overarching framework for law enforcement use of personal data in Europe, in the data protection framework. But then the Swedish Data Protection Authority said, well, you used the manifestly made public legal basis, which is in a way that this data has been public and we can then do whatever we want. It's not like this, but like in a very, very abstract level. Then they said, well, you actually need to change the law in order to be able to use this method. And then the Swedish law enforcement authority then implemented this IgG provisions in then ongoing biometric law updates, amendments, and then now they have this legal authorization. And in the Netherlands, they are using another legal basis that is mostly for dragnets for IgG cases. In Denmark, it was a bit of an interesting case because they are the only one that introduced the law before actually using this method. But they also did it a bit of an interesting way because they used what we call the citizens' proposal. And they had like 50,000 signatures and they presented in front of the parliament, and the parliament approved that law. And then based on that, the minister introduced the law, and now that became the IgG law in Denmark. So it was a bit more of a democratic process, even though it may have some shortcomings. And the last one is the French dichotomy, what I call, because they successfully solved some cases in France about with using IgG. But there's no explicit legal basis for that, and that was also a bit like criticized. And very recently, their justice minister expressed that he intends to introduce an IgG law. But there's one interesting fact here about France, because you cannot take direct-to-customer genetic testing services in France, otherwise you may be fined. But it seems that law enforcement will be, in the near future, will be allowed to use IgG for their cases. So I think it creates a bit of a dichotomy there. If we can go to next slide, and I'll be wrapping up in a bit as well. So I hope I'll still have some time to do that. One of the other issues is that, then I'll briefly wrapping up. Thanks for letting me know. So one of the issues also with the IgG is that even though it's a new shiny tool that we saw cases with it globally, more and more we started seeing that the cases solved actually shows us some of the shortcomings made in the past, or the flaws in the criminal justice systems, or not properly following everything that had need to be done. And one of them is the Norwegian case that you can also see it from the article. It's a case report of the Norwegian case. And after they solved and identified the now deceased criminal suspect, they actually realized that his STR profile was in the police records, but it never been actually registered to the database. So that means that despite the searches, they couldn't identify him directly, even though they could if they actually done everything correctly in the past. But I was told it was because of a legislative gray area very recently when I was in Norway. So we can still like bear in mind that this may not have happened even everything was followed because of legal strains, but just a case to show you that IgG may not always be needed every time, even though it's a useful tool. So if you can go to the next slide, and I can thank you for your attention. And if you would like to read more on this work, especially from the European data protection perspective, you can use a QR code. I can put the link in the chat so you can check a bit further about like what are the legal restraints and like the current legal overview in Europe. So thank you for your attention.
Thank you. Thank you. So I think it's a very good presentation because just like you said, like before we had a discussion about this forensic science use of genetic information. Any questions? Professor Jolie? And
I think
Ashley after.
Aisling, you had your hand first, so why don't you start and I'll follow.
Lady first.
Thank you.
Very
Thank you very
gentle.
much. And thank you, Tanner, for that presentation. It was really, really fascinating and a lovely lead on after Anya's presentation. I found it fascinating, all of it. But I just have a quick question in relation to the EU data protection framework. We obviously have a very robust framework for protection of privacy with the GDPR. I'm just wondering your view on the application of GDPR to these circumstances at EU level, and if you think these are effective protections.
So since I don't know the background of the cohort, I try to be a bit more like, descriptive in a sense. So if I have a bit of an opportunity, so to say, I can go a bit of the details of the legal framework in Europe without taking so much time. So we have two main pieces of legislation in data protection in Europe, in which is the GDPR that applies for, so to say, the direct customer genetic testing services and user relationship. But we have also law enforcement directive, which applies to the personal data processing of the law enforcement. And for IgG, they both find their application, but IgG, when we talk about law enforcement access, falls under law enforcement directive. Because if we talk about GDPR, then we only talk about let's say jet match and the user relationship. And in that case, law enforcement directive, it's a bit suffering from being a directive, whereas GDPR is a regulation. Because a directive means, well, we have this framework and needs to be implemented in member states individually, and you may have different rules. So, for instance, also for the IgG, like for different types of criminal investigations or like type of jurisdictions. So that's a bit of the shortcoming, law enforcement directive being a directive. But so apart from that, GDPR definitely applies to the relationship of, let's say, JetMatch, Family Tree DNA, or like other databases and the user.
Thank you.
So a great presentation, Tanner, very interesting topic. And I'm also really glad for a long number of years, the topic of forensic investigation with genetic data was sort of kept out the more broader genetic discrimination discussion. And a lot of people felt that, oh, because this is, states' powers, we shouldn't look at it in the same way, etc., which I don't necessarily disagree with. But I still think that it should be also reviewed under the discrimination framework. And I think that now the issue has gotten more attention, and it's of course, it's obvious that it should be looked at it through that lens. And it's also very interesting when you discuss with people that are involved in those investigation, how little of the ethical conversation that we often have in the therapeutic use of genetic information, when we're very much aware, when we put together a database to follow people for the treatment of different diseases, we're aware of the ethical issues. But when you talk to police authorities or when you talk to researchers in forensic genetics, the knowledge of the ethical issues is much less, and they often come out with that rationale of, well, it's for to protect the population and it's for the public good, therefore it's justified, and really there is no issue there. And so it's good to see the research progressing in this field. I also want to make an announcement, which is that the next meeting of the International Society of Forensic Genetics will be in Montreal next year. So I am involved in preparing a panel for the ISFG. So if this is a topic of interest and you'd like to contribute, do let me know. And I'm also going to organize a side symposium at my own institute on the topic. So if you'd like to participate to either of those, and let me know. It's going to happen in August. You can have the date on the website of the ISFG for the ISFG conference. So I really recommend it, and I think it's great to see the debate progressing. I'm going to stop here on my comments because I got a lot, but we can catch up after that, Tanner, and discuss more on your topic. Great.
Thanks so much. Do I have time to just briefly maybe?
Yeah.
Yeah, thank you so much also for the updates, and they're really interesting. I just wanted to mention one thing, and I also had the chance to work a lot with like police officers, and of course, like they have with all the good intentions maybe, but they have this how can I put it, like approach that they protect the most important right out there, which is right to life and right to security. And that's why sometimes other rights and considerations may be a bit like, overshadowed with the weight of those rights. But we have those curtails and like, the democratic lawmaking processes for like obvious reasons. So that's why like my job is also to be like, bring those discussions to the table and like have a bit of a more democratic rule-making process so that we can know like whether and to what extent these can be used and how can we make it not lawful but also legitimized in Europe. So that was also my like contribution, so to say, with my research.
Great to hear. Thanks again for your presentation.
Thank you. So now we'll have our next speaker, Ashley.
Thank you very much. So I might actually share my screen if that's easier for my presentation.
Sure,
Okay.
absolutely. Yeah.
Thank you so much. No, can everybody see that okay?
Yeah, it's not the full screen,
sorry.
but we can see it.
1 second. Sorry, I'm just looking for the full screen.
The thing is the right.
Should be on the bottom, Ainsley.
Yeah, the bottom on the right.
Okay.
The bottom right beside the minus sign.
Bottom right beside the minus sign. Okay.
Bottom.
Apologies.
The zoom out minus
I
sign.
missed it.
At the bottom.
The bottom right.
The bottom. Okay. I don't see an icon here.
Right.
Oh, sorry. Apologies.
Or you can press F5.
F5. Okay. Is that better? Apologies. No. 1 second.
On
Yeah,
the bottom
almost there.
Sorry.
Yeah,
Is that it?
to the left of the minus sign.
Left of mine. Apologies. Here we are. Got it.
Yeah, exactly.
Sorry.
Yeah, perfect.
I should know how to do that automatically. Okay, thank you, everybody. And first of all, just a huge thank you to Jan for his ongoing fantastic leadership on GDO, and of course to Song and Ariel and all the team for bringing this conference together. It's hard to believe it's a year now since Istanbul when we were all together there, and 2 years since Panama. But as always, I'm delighted to be here and and to present. My paper today is Gene Editing, Disability and Genetic Discrimination. Just to give you a brief overview of this presentation, so a lot of my research to date has been looking at traditional concepts of and emerging concepts of genetic discrimination, particularly in commercial contexts, such as in employment, in insurance, and looking at these issues from a disability perspective and looking, of course, at the regulation and policy issues that arise around these issues. So what I'm looking at now is the rapidly emerging area of gene editing, which, as we know, has been very rapidly advancing and developing in recent years, with huge implications for personalized medicine, for society, and generally for the human race. And as we know, these advances have fantastic opportunities for health and for medicine, etc. But they also raise a huge minefield of ethical and legal challenges, and particular challenges I think arise from a disability perspective. So this paper adopts a disability rights framework, a human rights framework to inform the discourse on gene editing regulation. It also adopts the framework of the history of eugenics, which I think is hugely important. And this has come up, it certainly came up yesterday with some of the papers. And it looks at historical abuses of genetic science to inform us as to the current issues arising today, and also to urge caution as to the consequences of advancing genetic technologies on certain vulnerable minorities, such as people with disabilities. So this paper is exploring this question of regulation of gene editing from the perspective of the UN Convention on the Rights of Persons with Disabilities. And this is an international benchmark for best practice in the area of human rights and disability rights specifically. It's our hard law piece of legislation. I know that point came up earlier today. And it's also very relevant to point out that 193 countries around the world have now ratified this convention, which is really noteworthy. It indicates the global influence and impact of this instrument, which is relevant to point out. The other small point I just want to make at the outset here is in relation to artificial intelligence. And I spoke about this in my presentation last year. And the convergence of AI and genetic technology is, of course, further accelerating the pace of these developments. And there was an interesting article a few weeks ago in Nature on this convergence of AI and gene editing. The specific focus on AI is outside of the scope of my paper today, but I just want to acknowledge that we can't ignore AI. AI is following us around everywhere, and it's certainly relevant in looking at the future of this area. Just some further background and context to this research is that there is, of course, as we know, an increasing body of scholarship on the emerging ethical and legal issues around gene editing. I think that there is somewhat of a gap in the literature on the intersecting issues of emerging gene editing technologies, disability, genetic discrimination, and the regulation of this area. So this paper is looking to address this gap and to bring these various different perspectives together, again, with that acknowledgement of the history of eugenics, the disability perspective, and how the UN CRPD can inform our approach here. So just some very brief scientific background here, and I won't go into this in too much detail, but as many of you know, gene editing facilitates specific and precision changing of an organism's DNA, and it involves the changing, adding, or altering of genetic material. Now, as we know, gene editing has been around for quite some time. It's not new. However, the debate in this area gathered particular momentum with the arrival and application of the CRISPR-Cas9 technology, which has been described as a game changer. It has been described as cheap, quick, and easy to use. It has promised to revolutionize genetics. It has also been described as significantly more efficient, accurate, and cost-effective, and less technically problematic than previous gene editing technologies. So it really is a revolutionary type of genetic technology. In terms of recent developments here, some of you may have been aware that in 2025, we saw the arrival of CRISPR 2.0, again, a medical breakthrough, and further accelerating the pace of developments here in terms of that move towards precision medicine. And for the first time, this gene editing took place inside of the human body, in other words, in vivo. And again, massive potential here in terms of the future application of the technology. And again, just to note briefly the advent of AI here, that it is further propelling the developments in terms of gene editing, and inevitably this will further develop in the future. Moving on to the ethical and the legal issues here. So there are, of course, varying layers of ethical debate in this area, and a huge minefield of moral considerations, ethical considerations that arise in this area. My paper is focusing particularly on eugenics and genetic discrimination, and looking at these from a disability perspective. So I'll just move on to that in a bit more detail, and to look at the disability perspectives here. So disability rights, in my view, are particularly at stake with these new scientific and technological developments. And people with current, future, and putative disabilities are particularly vulnerable to mistreatment, stigmatization, as well as a range of other violations of human rights. Genetic technologies, including genetic testing, gene editing, offer new ways in which to view and to identify disability, as well as to treat and potentially eradicate disability and potential difference in the human race. As I will speak about in a few moments, people with disabilities have historically been segregated, isolated, abused, discriminated against, with the history of eugenics. And this, of course, leads to a huge range of human rights violations. So just applying this to current developments in this area, advances in genetic science do have the potential to exacerbate these historical and existing societal attitudes towards people with disabilities. So just to look then at the concept of genetic discrimination here when we're talking about gene editing. So as we know, GDO has been hugely active in discussing. We've all been involved in discussions around the concept of genetic discrimination. We have been involved with crafting definitions of genetic discrimination. And in this context here, when we look more particularly at gene editing, I think that it gives rise to a new layer of genetic discrimination. At a societal level, I think that this genetic discrimination could provoke a more systemic type of mistreatment, which is very much rooted in discriminatory attitudes and eugenic type tendencies, policies, and again, attitudes. So just looking at a couple of examples here of how this new layer of genetic discrimination could arise with these new technologies. So use of gene editing could lead to genetic discrimination by creating a society where designer embryos or designer babies are valued over others, leading to inequality based on genetic makeup. And this, of course, includes potential discrimination against those with disabilities who may be seen as less valuable, less worthy, or whose disabilities or genetic differences may be targeted for elimination through eugenic type practices. And just to look at that in, again, a bit more detail in highlighting that additional layer, I wouldn't necessarily separate the definitions that we have been looking at, the more traditional definitions of genetic discrimination, but I would describe it as a further or additional layer, I think is the best way to look at it. And that, as I said, is rooted in this notion of eugenic type tendencies, attitudes, and policies, which highlights these technologies as potentially giving rise to an intolerance of difference, of diversity and disability. And in conjunction with discrimination concerns that could arise here, I think that we could also be looking at an issue around, changing perceptions of what is viewed as normal or acceptable in society. And again, that notion of stigmatization can be very harmful for minorities and vulnerable populations such as those with disabilities. And again, I think this is leading towards the potential question around eugenics and a trend towards eugenics. So I think that at the heart of some of the ethical dilemmas here in this area is that these advances in genetic science with new gene editing technologies, for example, may signal a reinvigoration of eugenic type, again, trends, policies, attitudes. And this focus on superiority and improving the human race. I think that the history of eugenics is really important to consider here, and many of you will of course be familiar with this, but eugenics was very prominent in the early 20th century. The two most stark examples of eugenics from the history books are from the US and Europe, in particular Nazi Germany. But just to note that eugenics was, of course, there are examples of eugenics from all over the world, from across Asia, India, Africa, South America. In Ireland and England, we had examples of eugenic type attitudes, eugenic type tendencies, and at the more extreme end, eugenic type laws and policies. Just to note the impact here of these laws and attitudes, eugenics of this time very much targeted those who were seen as inferior, those who were seen as genetically inferior, those with disabilities, whether it was physical disabilities, intellectual disabilities, mental health disabilities, and they were targeted at a government level through various policies and laws, such as sterilization laws, which were rampant at the time across America and, of course, Europe. There was also, at a more grassroots level, attitudes were very much eugenic in their impact. There's a great example of the Fitter Families competitions from the US, which again rewarded desirable families with good family heritage, etc. So I think it's important to look at the impact of that and what we can learn from those historic examples of eugenics today. So just applying that again today, obviously through these new technologies, there is a potential to promote the perfect genetically designed babies, a more enhanced human race. The technologies we have today offer significant opportunities to segregate, to discriminate against individuals, namely those with disabilities. And this, of course, raises a minefield of issues around whether this is eugenics. Is it eugenics in a different style of eugenics? And it raises questions around the value of a life and whether these new technologies could be used as a negative selection tool. Moving on then to with that in mind, with the issues that I've just mentioned there and the history of eugenics, a range of law and policy issues are provoked, and I'll just highlight a couple of these. So the question arises, of course, as to whether gene editing should be banned, either completely or in part, or until such time as the risks have been adequately addressed. Another question arises as to whether these technologies should be used, but only for therapeutic purposes and not for human enhancement. And then a more specific policy question arises, which particularly interests me, is how gene editing technologies should interact with human rights and disability rights. And this question is kind of further provoked as to how and whether gene editing could be used to improve health choices, to promote personalized medicine, and to do this without devaluing the lives of persons with disabilities, and with a view to upholding fundamental human rights. And that is, in terms of our GDO objectives, we have been looking at whether personalized medicine can, and promoting personalized medicine can coexist with fundamental human rights, such as protecting against discrimination and protecting privacy. Some further policy and regulation questions that arise here. I think it's fair to say that a legislative and policy vacuum in this area may result in gene editing being used as a tool for discrimination. I think that is a very likely outcome. Another important point I think to make is that any such void could also negatively impact upon public confidence in genetic science and technology, and potentially could stifle innovation in the field. This is also undesirable. I think that a balance is, of course, needed between protecting human rights and also encouraging scientific and technological developments. Just to note that the current global legislative and policy landscape is fragmented and diverse. But I do think that we can look to international human rights law for guidance on this area. And we raised the question earlier around hard law, soft law, what is the best approach? So just to briefly note some of the soft law that we have at international level, and there have been a number of relevant declarations from UNESCO on this, and they have the theme to be identified here is that they have called out the key human rights at stake here, namely the right to non-discrimination, the right to respect for human dignity and integrity. The point to note around these soft law instruments is that they, of course, have quite limited impact and enforceability. Moving on then to the UN Convention on the Rights of Persons with Disabilities, which, as I mentioned earlier, is a key legal instrument in this area. It is the first human rights treaty of the 21st century, and the provisions of the convention have been described as providing a moral compass for change. And that is a quote from Professor Gerard Quinn, who was centrally involved in the drafting of this convention. So the convention aims to provide fundamental human rights and equal treatment for persons with disabilities. It highlights rights such as non-discrimination, the right to respect for dignity and integrity of the person. And it is also noted that disability as a concept is very broadly interpreted in the UN Convention on the Rights of Persons with Disabilities, and it applies a social model theory of disability. So this looks outward to external factors, to the environment, to societal and individual attitudes as being responsible for the discrimination against an individual on the grounds of disability, as opposed to the medical model that looks at the individual and their medical condition, their disability, etc. Moving on to look at the relevance and application for gene editing in particular. So I would argue that the UN Convention here provokes questions about the compatibility of genetic technologies and screening policies with fundamental disability rights principles. Now, just to note that the Convention does not directly address the use and impact of genetic technologies, but it certainly does provide law and policy guidance on the emerging issues here from a human rights perspective. So just to look for a moment at the right to equality and non-discrimination. So it has been stated that the UN Convention on the Rights of Persons with Disability lets the non-discrimination principle do the heavy lifting in terms of safeguarding and protecting the rights of persons with disability. So it's very prominent in the convention. I would argue, and I have written about this on various occasions, genetic discrimination is prohibited by the UN CRPD. The misuse of genetic information and the mistreatment on the grounds of genetic predisposition to disability are arguably contrary to the UN Convention. The concept of discrimination and non-discrimination is quite broad in the CRPD, and I think it is a very useful principle to apply here. As I said, it is very prominent in the CRPD. Non-discrimination is called out in the preamble and also specifically in Article 5 of the CRPD, which prohibits discrimination on the basis of disability and guarantees equal and effective legal protection against discrimination. So I would argue in this respect that by prohibiting such discrimination, Article 5 promotes the appropriate and, where required, the limited application of these technologies. Just to briefly highlight then the right to dignity and integrity, and of course when we're talking about any interventions into the human genome, this goes hand in hand with the integrity of the person, and there is a huge potential for the right to respect for dignity and integrity of the person to be violated in these circumstances where the technologies are misapplied. The right to dignity and integrity of the person is very prominent as well in the CRPD, again in the preamble, and also specifically in Article 17. Moving on then, just one further provision that I'd like to highlight in the UN Convention on the Rights of Persons with Disabilities is in Article 8. And this is, I would say, somewhat of an unusual provision, but a very valuable provision in my opinion. It advocates an awareness raising and educational campaign in this area. And I would interpret this that awareness raising should take a broad approach and encompass attitudes to genetic technologies, as well as education and awareness around emerging gene editing technologies. And I would also argued that Article 8 could be used as an impetus to encourage the use of awareness-raising campaigns in conjunction with legislation to educate as to genetics and the limitations of the technologies. And I think this will be very useful in addressing the attitudinal barriers that we see to disability and to other diversity. And I know that Athira mentioned this yesterday, that there is also a lack of awareness in India in this area. I think that this is a universal concern, that we need awareness raising and education and appropriate public engagement on these issues. So I think ultimately the CRPD could be used as a catalyst for reform in this area. I think at a minimum, it could highlight the key human rights necessary to consider in the regulatory process. Just looking, I'm just conscious of the time, so I might just move forward to the conclusions. So just kind of drawing those points together and concluding, I think that the rapid advances in gene editing and the future use of gene editing exposes the vulnerabilities of certain minorities, particularly those with disabilities and those who might find themselves discriminated against, stigmatized, screened out of processes, etc. I think the history of eugenics is a very relevant framework to consider when we're looking at modern day abuses of genetic science and technology. I think that as the gene editing technologies continue to evolve, which they necessarily will, it raises really critical questions around this balance that we've spoken about between advancing genetic science and technology, the move towards precision medicine, and fundamental human rights, and whether or not they can coexist. I think the UN Convention on the Rights of Persons with Disabilities provides really relevant guidance here as an international benchmark for best practice in human rights. I also think, and we brought up, as I said, the conversation around hard law and soft law, and it really is, I think, a tricky one to consider in this area, because with the advances, with the technology and the science advancing so quickly, it's very difficult to craft hard law that may become out of date very quickly. On the flip side of that, soft law initiatives in this area, while they can provide a good benchmark and provide guidance, they may not have the robust framework of impact and enforceability. I think just some initial thoughts on where we might be going from a law and policy perspective. I think in addition to a legislative framework, I think that we do, of course, need further dialogue, further multidisciplinary dialogue on these issues. I think that additional policy initiatives are needed in this area. So effective and meaningful public engagement and dialogue on these issues. And there are many examples of how that has been carried out in various places. And I think awareness raising and education is important here to accompany any legislative endeavours. Thank you.
Thank you. Thank you. Wonderful presentation. Any question? Oh, I think Don Rich, right? Don Rich
Greetings.
has a question.
Greetings and congratulations on a stunning presentation. So this is also one of my fields of interest. I've just signed off a proof for a protocol for a survey among South Africans to test their opinions on various aspects of the use of gene editing. So sketch a future scenario where it's possible and where we can use it from anything from health issues, immunity to enhancement, and also some aspects such as preventing albinism, which is a quite sensitive topic in South Africa, and that links very directly, of course, with disability. We had a public deliberate engagement, citizen jury a few years ago, so we're planning the same again, but first there will be a general survey. So I'll keep you posted. But I just want to challenge something. I think the idea that we will be valuing certain embryos more than others is already a fact. We, at least from my perspective or South African perspective, we most certainly value certain embryos more than others. We test them. We value them. it's become almost standard to do PGT, pre-implantation genetic testing, and then we know which ones are euploid, which are aneuploid, and we destroy the aneuploid ones, we use the euploid ones. But the fact that we value certain embryos more than others doesn't mean that if they result in humans, we will value, at least as a legal system, and hopefully not a society, value certain people more than other people. And exactly this question was, in fact, before our apex court, our constitutional court, where there was a wrongful birth claim, and the argument against it was that if we allow this type of thing, because there was an error with it wasn't PGT, it was NIP, it was it was a screening by the mother. The mother's blood was screened, and the clinic made a mistake, so she did not abort, and she had a child with Down syndrome. And then the child, actually, if I remember correctly, claimed represented by the parents, and successfully. So the court allowed it, unanimous decision, and they viewed that as a harm towards the child. And then, but the argument was, but doesn't that now mean that we are valuing certain lives more than other lives? And the court said, absolutely, absolutely not. The child's life is valued absolutely, but, and they also didn't want to call it wrongful life. They had lots to say about that nomenclature should completely change. So they say the life is absolutely valued equally with other lives, but we still recognize that that constituted harm. If you cause disability, that in itself is a harm, and the law will recognize it. So I don't want to go on. I just thought it's important to make that distinction. And then if you think, however you define eugenics, there's a certain purpose that might be better health, whatever the case may be, and we can perhaps agree that that's a great purpose. But what went wrong in the past, the examples that you mentioned, was the means. How did they want to accomplish it in seriously discriminatory, human rights infringing means? Clearly, there can be, we can all strive to better public health, but in more humane, human rights respecting fashion. Thank you so much. Great presentation, and I hope we can stay in contact regarding these issues.
Absolutely. Thank you so much, Donric, and really interesting to hear about your new project. And I'd definitely like to hear more about that. And in Ireland, we also had a similar, and we spoke about this, I believe, in Panama, was it 2 years ago? In Ireland, we also had a citizens' jury on genomics.
Yes,
It was a really fascinating project to be involved in, where we got the public involved, gauged attitudes, educated, ran a number of workshops, trained, etc. And it was really very effective. And I think that needs to be implemented even more. But you're right on many of those points you raise, and you raised a few of them. Just I suppose in relation to eugenics of the past, it's fascinating to look at. It is different. It's a different type of eugenics that we're looking at today, and I think it's more subtle in many ways, because what was problematic about the past was that it was very often government-sponsored eugenics.
State enforced against people's wills.
Absolutely enforced. The compulsory sterilization laws, for example, the many discriminatory, stigmatory type of laws were very harmful. And it's different today because we're looking at individual autonomy in some ways, and reproductive autonomy, and it's a very delicate. This is a very delicate debate, I think, because there are so many different perspectives and different viewpoints. And in terms of, I suppose, the value of a life and the selection of an embryo, as you rightly pointed out, that does already happen, right? That is a reality that, pre-implantation genetic diagnosis is used, screening policies are used. I suppose, and I'll give you an example. Several countries around the world, I believe Iceland is one of them, they introduced various screening policies for Down syndrome, and the impact of that was that they rapidly reduced the number of Down syndrome births in these countries. Denmark was similar, and I believe New Zealand. But in Iceland, there was a documentary that I watched on that, where they went to Iceland, and there was just a handful of individuals with Down syndrome, and they spoke from their perspective about feeling devalued and feeling like their lives weren't as valuable because the screening policy was in place. So I think that's just an example. Again, not look, I think that, as I said, we can look at genetic technologies coexisting with fundamental human rights. And what I think is important is just that there are these protections, these non-discrimination protections in place. But
Indeed.
I think that there are, different ways of looking at it, certainly. But thank you for the question.
Thank you.
And
Thank
I
you.
can
Any
tell
comments or
you,
questions?
I can tell you on that last position, Aisling, that's also the position of my mentor, Barta Noppers, and she would have repeated it if she was there today. That she has always looked at that question of genetic discrimination through the disability angle, and she feels that it's actually sufficient to do that, and that many of the specific prohibitions are actually unnecessary, and that this would allow us to have a broader perspective into the question rather than limiting ourselves and then asking ourselves, well, should we expand to this and that after? So definitely a very interesting angle to look at genetic discrimination from. And I apologize, Song, I think you wanted to ask a question.
Oh, no. I just want to ask anyone has more comments or questions before we move to the next session.
Okay, thank you, everyone. Happy to
Thank
take
you.
any questions if anyone has them afterwards or in the chat as well. Thank you.
I think the next session is Professor Yuli.
I think the next section is starting
Is
with the
the
break because I think we all need it after those great presentations. Why don't we all take 10 well-deserved minutes of break, 11 actually, and get back at 15 past the hour, and we can have a discussion on the research work that we're going to do in the next year. Thank you. So in
Great.
15 minutes.
See you soon.
Okay, I think for those of you that are here, if you can start opening your screens just so I can get a tally of whether we're sort of ready to start that discussion. Thank you. I'm seeing people coming in. And I don't know who's responsible for the slide. If that person could put on
Jessica.
Jessica. All right, Jessica, if you don't mind, if you're here to put back the slide, there is one slide that I want to show for the discussion. So this is basically the part of the meeting where we discussed among each other, members of the GDO, about what it is that we want to do in the coming year as group work, as collective collaboration work. Yes. If you can advance on this next slide, Jessica. Next slide. Yes, thank you. Okay. I'll go in inverse order because I think the slide before is mostly reminder points that, or maybe, okay, why don't we go back one? I'll do the reminders first, and then yeah, I think that core team, all I want to say, and the core team, by core team, I mean the people that help me run the GDO on a day-to-day basis. I'm just very grateful for that core team. We've had a lot of movement last year, people, and it is a fact of life in universities, moving on, chasing other opportunity, progressing in their academic curriculum, etc. We have lost the Uberoy, or my associate director, and of course, I'm really glad that people could step in and help me to put things together for this meeting. So I do want to acknowledge them and thank in particular Song Ling Kwao for that. She's done a great job stepping in and helping prepare this meeting. Other point I want to make as to the core team, it's really difficult to fund a team to work on the GDO these days. I had some partial funding up to 2025, and I don't have any funding for 2026 at this point. So I really have to use other budgets and voluntary times of people to do this. So if we can have a thought when we're going to discuss about the research activities about funding as well, it would be very helpful. Contribution to tools and features. This is where I really want to emphasize that we need your help. GDO expert on the expert advisory group, GDO collaborators, we really need you to help us have our tools up to date. And by tools, I mean mostly our maps. So we have various maps, and I recommend the best way for you to know about those maps, if you're not aware of it yet, is to go on the GDO website and to look at the tools and to look at the maps. And basically, they map different aspects of genetic discrimination, whether it is the evidence of genetic discrimination, the laws, etc. And see for yourself if the maps are up to date and they reflect your country. You're the expert on your country. You're the best person to tell us if the maps are up to date. So please help us do so. Help us make those maps up to date. And same thing, we have started a process. Many of you have talked about the need for more information about genetic discrimination. I'm a big believer that the problem is as much a problem of information and as a problem of policy making. And if you can help us by putting together a short, I think it's 5 minutes video, or I don't know how long it is, Song. Maybe you can provide the details in the chat, just some basic fact about what's needed for the video. But basically, it's really not a big undertaking, just describing the policy framework in your country that addresses the question of genetic discrimination, trying to speak in as lay term as possible so that those video can be widely accessible. It would be really appreciated if you can help us do that. And the question of sustainability, I've already touched upon. We need to find ways to get more grants. I remember yesterday somebody saying it's challenging in my country to get funded in on the topic of genetic discrimination. It is very challenging in Canada to be funded on the topic of genetic discrimination. One of the issue is that it's a very polarizing topic, and that what I've noted is that on the referee panel, people have sometimes that assess the applications. Referees have very different viewpoints on how we should address genetic discrimination. And if you're not somebody that followed their own particular viewpoint, they will tend to classify this as, no, this is bad. And so it's very challenging. And if you put into that the current economic crisis we're facing, we have to be very creative to be funded in that particular domain. We still have an ongoing collaboration with GA4GH, the Global Alliance for Genomics and Health. We have a genetic discrimination work group. And the next topic we'll tackle with GA4GH will be the topic of group discrimination and stigmatization. It's a topic I've been wanting to tackle with GA4GH for many years. It's just that we got busy on some of our other things on our genetic discrimination agenda. But now we're really in a position where 2026 will be about group discrimination and stigmatization. So if it is of interest, please follow what we're doing with GA4GH, and we'll be very happy to include you in some of those activities. Now you can move on to the next slide, Jessica. So with what I've just said in mind, here are some of the topics that we could be tackling in 2026 as a group. Some of those topics I had thought of before the meeting, and then I've added things according to the discussions that we've had so far, the presentations that we've had. I might have missed things, and so please let me know if I have missed something as well. And when I say topics we could be tackling, let's be creative. We can do research if it's not too demanding. We're all working on voluntary time on this. So research, we can write papers together. We can do presentation. I was talking about the International Society for Forensic Genetics, for example. So we can do presentation sessions together, etc. So with that, I'm just going to mention the topics that we have right now on the screen, and I'm going to open it to debate because that's really what I want for the next half hour. So topics that I have right now, at the intersectionality of genetic discrimination and AI discrimination. So intersectionality is really a term to say that the same people always end up, being the victim of discrimination. It's always on the same group, on the same person, and it stacks up this discrimination. And so is that a phenomenon we can observe between GD and AI? And there was discussion also in some of the previous presentation of should we address those topics together? My inclination is to say maybe not all the time, but maybe there are some low-hanging fruits where we can actually tackle those two issues together. And as you know, AI is a very popular term these days. It's a very popular topic. So that would be great if we could go in that direction. Of course, we are working currently on a paper on genetic discrimination and pharmacogenetics, and how to basically help access to pharmacogenetic drugs and tools, but at the same time prevent that disinformation be used in a discriminatory manner. I think it's a great topic. The paper was one of the most challenging I put together, but I'm quite excited with the results so far. Do we want to push further? Then What are the needs for evidence, policy, or tools from our stakeholders? So, what do you think is needed? Taking a participant, patient-centric approach, what do you feel is the most needed in your respective country? What do you think could be the most useful? Thinking of these various stakeholders. Again, if we want to be a successful organization, I think we should never forget who we're standing for. And we have a consultative committees that have patient representatives. Some are quite active. So it's really, thinking about our stakeholders and what they need. Hard law, soft law, and global inequality. I think, Talia, you inspired this topic by your presentation, but also I think many of us touched on different aspects of this. It's really the question of how can we use policy in a way that is effective to, I would say, uh, not completely end those global inequality, because I simply don't think we can do this overnight, but certainly work, redress some of those inequities is probably the best way to say this, instead of making the gap wider through genetics. Uh, Privacy and discrimination law, as I've mentioned, and as we saw from the discussion this morning and yesterday, these are very complex law, and they're getting more and more complex, partly because genetic is complex. So what do we do? And for me, this leads to a very important conclusion, which is I see a lot of countries adopting law, but I see a lot of problem implementing those laws in a straightforward manner, both in the privacy and discrimination forum. Is this a topic that we would be interested in addressing? So that gap between adoption and implementation. Then the use of genetic data in forensic investigation. We saw this with Tanner's presentation this morning, and there were discussion also in Anya's presentation about this. It's definitely a big topic, and with the conference in Montreal next year, maybe this is the year to tackle this as a group. And finally, is GD? Oh yes. So sorry, I was just drafting this quickly as I was listening to presentation this morning. I think that this was inspired by Mark's talk yesterday, and it's this idea that genetic discrimination is a source of concerns, not context, for patient. And asking herself, well, how much does it actually impede clinical genetic testing, and trying to find a way to document this. Uh, and I think also Mark made some good point about context specific, saying, US law is born because of a specific context that we have in the US. He had a very interesting discussion also with Barta about the fact that for him, coming from this US perspective, life insurance was not necessarily viewed as an essential social good, etc. So I think that there might be room for these kinds of inter-country comparative sort of work in both law and policies more generally. So these are my starting suggestion for this morning. Thoughts? Do you see some things as more interesting, timely? Aisling, why don't you get us started?
Hi, thanks, Jan. I had just a quick question, just while it's in my head. You mentioned that it's getting harder to secure funding for genetic discrimination activities, that it's polarizing, etc. And I absolutely see that. I'm just wondering, is there a different way that it could be framed that would be more attractive? Is there anything that we could brainstorm to, because it's so, we all know it's so important to be looking at these issues, and it really should be funded. But is there anything, I suppose, in terms of being strategic, politically strategic, is there any other way of framing the activities that we're doing?
Yes, my first answer is to say not use the word genetic discrimination because it's very unpopular, especially in countries that have adopted laws, because then it's sort of a recognition that well, we didn't do such a great job at it. So nowadays in Canada, because Canada is very big on equity, diversity, inclusion, I probably, my gut instinct is to say if we go with inequities, equities, and this sort of language, even stigmatization, that would go better. Anya, do you have some thoughts on this?
Yeah, thanks. I was thinking about this a little bit when you were talking about how AI is, the buzzword right now. And I wonder if another way to frame it is the strengths that we all bring from our knowledge of genetic discrimination. So I wonder if, like, for that particular one, you could say, like, what could our, existing journeys of protecting against genetic discrimination teach us about AI? And I'm thinking in particular the benefit sharing conversation that you had with, now I'm forgetting which conversation that came up in, but I thought that was so interesting um, um, to like do people within the AI world know about this concept of benefit sharing? And that's might be more obvious to a group like us, but not obvious to another group. So, and that isn't to say that we would pretend that genetic discrimination has been solved, but I wonder if it's like a sneaky way to be able to um, address the existing gaps uh, while also pitching, like, here's the strengths we have, and we're gonna then take a leap forward and say, what can we teach people, or what lessons can we draw into this new space?
Yeah, no, I think there's a lot of interesting points that you've just made here. I think you're right. I think it would be great to pitch, to pitch our own, whatever funding demands we do, with the angle of coming from the world of genomics. There's a lot we know about discrimination, for example, based on health data, because that's what a lot of her research have bared upon, in the context of genetic discrimination, context of benefit sharing. I asked Sujit earlier when he presented on this, because I also have not necessarily seen any of this discussion about benefit sharing in the context of AI. I wonder if I should look if Calvin O has published on this, because that Calvin as an interest in AI and these questions of global equity. So he might be a good person to look for to see if he's written on this. And if not, my sense is probably there isn't much at the time. And speaking to Calvin, he also had told us, we had a meeting in Ayers Cliff that was organized by Barta last fall, and Calvin was discussing AI and health, and he was saying that China and our representatives from China may want to comment on this, had an approach to AI where AI was almost sort of considered like a pathogen or under a biosecurity filter or lens. And I thought that this idea of looking at AI under a biosecurity lens was quite intriguing and interesting, and again, an inspiration from the genomics world. So I think there would be something out there to look into.
Can
Any
we add
other?
something? Yeah,
Yes, of
Kshitij.
course. Sijit, go ahead.
Yeah. So, on your point on benefit sharing, uh, like India has one policy document which is termed as AI for all. That is very much about the inclusiveness. But how we define benefit sharing, that is something which we need to work upon, because it is just used to, make collaborations, or you can say local contextualization, or you can say capacity building, so on and so forth. So it is loosely defined in that way as we usually understand what is benefit sharing. So how it could be contextualized in the case of AI is still, I think, very evolving. So that may be a catchy idea. The other thing which I want to push is, though you are not great fan of right to science, but sometimes if we go for the justification, for soft law, something like that, do you think that right to science could be pitched after COVID and all that, like a good justification for, developing ethical frameworks, or you can say moving with the even legislative framework?
So it's interesting. I actually am a believer in the right to science, Sijit. I do
So
want to make that very clear.
I had a
Uh,
conversation
it,
with you, but you were not that convinced at that point of time. So that's why I'm just, mentioning it.
I'm just, I'm just careful not to overextend it,
Yeah.
because it's a right to scientific progress, and sometimes we sort of assume that there'll be positive progress out of every scientific research, and I've seen people just draw too much out of the right to science, and that's where I would personally be a little bit more cynical, but I totally think that the right to benefit from the science, the knowledge and the science that is being generated. And again, the formulation of that right is quite specific. So I think we would have to look into that specific formulation. Regarding benefit sharing, a point that I do want to make is that if you look at the WHO work, there's been a lot of progress on what benefit sharing is and how we should be doing it. And I'm thinking of course, I think it's the Kyoto Declaration. I'm thinking of the Convention on Biodiversity, and I'm thinking of the recent attempt at a pandemic treaty. So there's a lot of thought that has been put into this by the WHO. The problem is that at the structure of the WHO, since the US has left, is kind of shaky, and things are not advancing there. But that doesn't mean we can't use some of the theoretical work and some of the thought that has been put into this question, where they really started to think about it as a contractual requirement, and to how to implement this as a necessary contractual requirement when you were doing research in the global south.
Thank you.
Sure. Other thoughts about topics that would be interesting to tackle? So AI is getting some buy-in. Are we looking at other topics? Are there other topics out there? Am I missing some topics that people have covered, gave you good ideas of what we could do?
Hi, Jan. Just to endorse those topics, I think that is a really great list and very comprehensive. And AI and genetic discrimination in itself is massive, and there are lots of kind of areas associated with that we could look at. So I think that would certainly keep us going. I think if that was our list, I think it's really topical, really comprehensive, and definitely covers a lot of what we talked about today and yesterday.
Yeah, I'm definitely not gonna. We're not gonna address all those topics. I can tell you that
Yeah.
in 2026. Although I wish I could, I'd be delighted. But we're gonna have to pick, and that's where I need your help. Yeah. Song, you had your hand up.
Yeah, I just want to follow Anya's proposal regarding the definition of genetic discrimination, because I'm also thinking with the application of AI, so maybe our definition will be different, like including algorithm discrimination, like Kashidi talked about data sovereignty, all these kind of things maybe have influence on our definition of genetic discrimination. And there's another point is the loss in translation. That's why it's important to have a comparative study, because from my understanding, in Chinese context, we avoid using a discrimination, the term, even like we don't want to use it or to show it in the legal context. So it's important to look at it, and I found it might be interesting and meaningful.
Thank you, Song. I definitely think, context-specific studies that would be well done, and comparative law, but that would go really beyond the positive law, might be something that would be quite interesting to think of, and definitely keep it on the top of my list. I'm not eager to revisit the definition of genetic discrimination simply because we've done a paper on this 2 or 3 years ago. So I think we could do something, but on that, but I wouldn't have it as a main focus for research simply because it would be difficult to pitch it given that we've done something on it, and the same thing as at the level of publications. And we have done a definition that we had at the time kept extremely open and broad because we wanted to make sure that whatever would happen would be encompassed by that definition. So, Charles, and then I'll try to look at also the chat where Mayumi has put in some suggestions. Go ahead, Charles.
To continue on that topic, not to change the definition, but I think there's perhaps misconception on genomic risk or public understanding. That's hence the funding or the grants that we need. Perhaps that's something we can do is to reframe or find some and use more the AI word definition like responsible inclusion so perhaps just try to think more about the public understanding and we can do something about it, I think.
Yeah, I think the point of looking at it and looking at something that as some commonalities between AI and genetic discrimination and AI discrimination is what I'm interested in, and the overlap in terms of who gets affected and how does the process work. That part I'm completely sold to. But coming up with a new definition of discrimination just for those two, or I don't really see that particular point personally, but I can be convinced. All right, Mayumi, do you mind voicing what you've put in the chat? That seems quite interesting.
Oh, thank you. I just wrote that I had an opportunity to participate in a WMA, World Medical Association's first expert meeting, which is discussed about the revision of Declaration of Taipei. And the declaration itself focused on the health database and biobanks, but the topic itself was more focused on the AI and secondary data use. And they didn't much talk about the discrimination, but they also talked about a little bit about the benefit sharing. And that reminds me of Jan Sensei's comments about AI discrimination and benefit sharing. And if we could write something about this topic, WMA could we could contribute some of the discussion about the visual of Declaration of Taipei, and their goal is October to 2027. So we still have time to discuss about this topic and propose something useful for their revisions. Thank you.
Seems like an excellent idea, Mayumi, and nice to see you, by the way. It seems like a great idea. I like it because both from a theoretical perspective, it interests me, but I also like it when we can affect policy change. And this seems to be, and the timing seems to be also quite good in that it would leave us some time to think about this. So I would definitely be interested in looking more at this idea. I would need to see a little bit more about where Taipei is at. I have to say I haven't followed as much as I should, and so I need to put that back on my radar. But it seems to me like it'd be an interesting proposal.
Thank you.
Thank you. Xi-Sing, please go ahead. Nice to see you as well.
Hi, nice to see you, Yang. I was just happy to endorse Miami's proposal because I think nowadays when we talk about the genetic information or genetic data, actually most of people focusing on the signal use of data. And just about a year and a half ago, and the National Health Research Institute in Taiwan, we did a year study about something like genetic discrimination issue, but we changed the topic to how to protect genetic information. So even though the final goal probably might be similar, but the framing is completely different. So when we focus on the how can we protect genetic information, actually it's much broader, and it could include many issues that haven't really been covered by the genetic discrimination, especially for signal use of data, because how can we use genetic data beyond the original consent? And can we, for example, now the European Health Data Space, now they require this legal purpose to use genetic data. So to what extent can we allow this way, or what kind of purpose that need to be prohibited, for example, for direct marketing or insurance purpose? So I think it's probably a doable topic, and it could border the possible research orientation that we are now focusing on. Thank you.
Thank you, Shising, for that perspective. And I would say that I like the term protection. My only fear is I wouldn't want us to equate protection with privacy, because I think sometimes people think that adopting, a good privacy law is going to resolve the issue, and they think of it as an end in itself. And I think that privacy doesn't capture all the risk of genetic discrimination. We know that privacy has its limit, because simply people are getting better and better at re-identifying data. And that also, if we want to share data at some point for research, we have to accept some level of risk, small risk. So basically, privacy is not sufficient to prevent discrimination in itself. But if we can have, under a broader umbrella of protection, both of these concepts, privacy, discrimination, and maybe other related topic, then I think that could be an interesting place older, a name to sort of, guide our research. So thanks for contributing that idea.
Thank you.
Any other thoughts? And do people like those group publication that we've done in the past few years? I've tried to keep it at one a year. I know that they can be tasking. Is that a way of working that people are enjoying and feel is helpful? Would you suggest some other ways of working? So Aisling is giving me the thumbs up. Thank you. Are there any comments on the way we're working? Are we happy with that? Or it could just be suggestion of how to do things in a different way? I see satisfaction. Don Rich, you usually quiet. Can I call you up and ask you what are your thoughts on this matter, and if you have some suggestion on some of the proposals?
Thank you. I'm specifically interested in the issue of group harm, but I've now been thinking of how to formulate a topic because, as you've now just said, privacy legislation is not the cure-all. It's not a panacea for genetic discrimination. But I was thinking of typically in our privacy protection laws, it's very much individual-oriented. It's the individual's data that's protected, not a group, or you're also not protected against a family member providing data. So something that interests me specifically that falls almost be that falls a little bit on the periphery of autonomy is when embryos are genetically tested, say a whole batch of embryos. And typically then the clinic would claim ownership of the data. And only one or two of those embryos will eventually be used or result in a live birth. But the clinic will then have not only theirs, but also all the potential siblings' genetic data. And it all, obviously it's got commercial value for the clinic. But what can then be the effect on the living individuals whose genetic siblings that never made it, their data can then be commercially traded, etc., because they fall they fall outside the protection of our typical data protection legislation because there's no living individual. But still, it affects living individuals, although it's not my personal data or a living individual's personal data. It's a I don't want to say hypothetical.
Well, as a
It's a
sibling, wouldn't you have an interest in the data
you
as
would
that
have an
sibling?
interest. You would have an interest, and that exactly is the problem, because the way in which data protection legislation is formulated is you've only got a legal right if the information pertains to you. In other words, if the information, if you're the data subject. So at least that's my understanding. And I think that is problematic because clearly there is an interest that doesn't fall within the right that is now typically protected. And I know it's very much focused just on privacy or data protection legislation, but so I think there's something there. As you see, I'm still struggling to articulate it. So
Yeah.
perhaps that's why I was a bit hesitant to participate. But I hope I've communicated my general idea. I
So,
don't
so
know
I'm
if
I'm I'm intrigued by what you're saying, and I can tell you a similar area that I've in the past looked into was the right to privacy of people that had passed away, and I don't know if that could be useful to your
exactly. It's the same kind of thing because the moment you pass away, at least in South African legislation, then your privacy protection evaporates immediately.
but it can be invoked by your descendant
Uh,
because
uh, uh,
they, well, in
well,
Canada
yeah.
it can.
Okay.
And so
Okay.
that's what the interesting bit is, because the descendant can claim that they are impacted by some of the revelations and things like that, that it
Hmm.
affect their own privacy interests.
So,
But I haven't looked
mhm.
deeper than that into it. But I think that's a nice
S-
trail to maybe think about.
yeah, so I don't know how, so clearly there are differences between the jurisdictions. So perhaps I'm a bit, well, obviously just focus on my jurisdiction, but it might be interesting to have a bit of a multi-jurisdictional study on this and see how it's dealt with, how these problematic scenarios are dealt with between a few jurisdictions and what we can learn from each other. That's a possibility. Then there's also the model law on health data. Um, and that model law does work with the idea of group harm. And and whenever health data, which would include genetic data, is then used, and there's any kind of relationship with any kind of identifiable community, then there must first be consultation with the community and potential benefit sharing with the community. So having a look at that model law on health data governance might also be an interesting link here, if people are interested, because it touches both on the community aspect and on the benefit sharing aspect. Yeah,
Yeah.
those the, those are my ideas. Thank you, Jan.
No, that's totally interesting. And Anya left a comment that this was also relevant to the 23andMe bankruptcy, this question of deceased individual. And I can say furthermore, it was also something that came up during the decode experiments in Iceland. You might remember that they had a national database in Iceland a few years back. And again, that question of, can we withdraw information from deceased individual came up. And so maybe it's something that we want to look into and dig deeper into, and maybe you can apply it to your own conundrum, Don Rich, on what happens with the information on the discarded embryos. So in any case, we're running to the hour. I don't want this discussion to end necessarily. I do want to leave you your time off so we can have you back for the presentation a bit later in the day or in the morning, depending on where you are. So my suggestion is if I can add a little bit of work on all of your shoulders, simply, let's continue this discussion in the chat at the next session until the end of the meeting. If you have ideas, just keep that particular slide in mind and some of the suggestions that are on it. And let me know if you have preferences, if you want to make additions to that slide, etc. I really want, this work that we're going to decide to carry out for 2026 to really speak to as much as to as many member of our international expert group and collaborators as possible, so that we can really have a nice synergy work going into these activities. And it'd be great if it's also a low-hanging fruit from a funding perspective. So on that note, I want to thank you all for being here for this last session. We've had some terrific presentation. It just seems to be getting better and better as the meeting progresses. And looking forward to the next session, which will be at 8 p.m. Eastern Standard Time. I know some of you probably in Europe and in South Africa, yes, Don Rich, would not be able necessarily to view it. We're recording everything, and it is our intent to ask permission to all presenters individually to be able to publicize their talk on probably the GDO website so that people can view them. So you might have the opportunity to view these presentations. Thank you, everyone, again. See each other in a couple of hours. Bye-bye.
Well,
Thank you. Bye-bye.
Okay. All right. So good morning, good evening, good night. Hi, everyone. It's been a great opportunity to be part of this conference, to hear from all of you who are leaders in this field. My name is Jeanette, and I'm a genetic counselor practicing in Singapore within the Cancer Genetics Service at the National Cancer Centre, Singapore. The centre sees approximately about 70% of cancer within the country, so we are the main centre. Here's a picture of our sunny Singapore skyline and the Marina Bay Sands that we are so proud of. If you haven't been, you should come. It's a beautiful city. It's just really hot. And in December, it's considered winter because it's a monsoon season, so it's always rainy here in December. I trained in Australia, and I have a keen interest in the ethical provision of precision medicine and the impact of genetic testing results on insurability. In Singapore, our Ministry of Health has made precision medicine a priority, and we have recently embarked on a whole genome sequencing project for 100,000 unselected individuals within our population. The previous whole genome sequencing study of 10,000 Singaporeans found that hereditary cancer syndromes are actually not rare. They are a lot more common than we previously thought, where 1 in 150 Singaporeans were found to have pathogenic variants associated with the hereditary breast and ovarian cancer syndrome, and this is compared with 1 in 400 to 500 reported elsewhere. With the increased prevalence, particularly in the Malay populations, wherein founder mutations have also been discovered. This has really driven the need to raise awareness and community access to genetic testing. Genetic services in Singapore has evolved significantly over the past 2 decades. About 15 to 20 years ago, there were very few services, and most were rooted in general or pediatric settings with relatively limited reach and specialized focus. Since then, we've seen a rapid expansion, particularly in the area of cancer genetics. Over the last decade, the uptake of cancer genetic testing has grown dramatically with more than a 40-fold increase. Today, about 80% of our patients who are offered genetic testing actually go on to complete it. And this reflects greater awareness amongst clinicians and a growing confidence in the value of genetic information for cancer care in Singapore. However, despite this progress, cascade testing remains a persistent challenge for us. Fewer than 30% of at-risk family members undergo testing, even when a pathogenic variant has been identified in the family. And this gap highlights ongoing barriers, including communication within families, perceived relevance, logistical issues, and concerns about insurance implications, all of which limit the preventive impact we could achieve with genetic testing. And from a public health perspective, we've also calculated that, for genetic testing to be cost effective, cascade testing needs to reach a level of 36%. So we're not hitting that level. We're not hitting that cost effective threshold in order for subsidies to come in to cover the cost of genetic testing. So this context really sets the stage on why strengthening policy, education, and support systems remain crucial as we move forward in this era of precision medicine. We conducted a few studies to understand why the needs of carriers and at-risk family found that one key reason cascade testing remains low is the fear of insurance discrimination. We see many at-risk relatives declining testing specifically because they're worried about how the results can affect their ability to obtain insurance. So even when they understand the health benefits, this perceived insurance risk outweighs the medical value for many of our families. As a result, a substantial portion of them who could benefit from early detection or screening never proceed with testing. And this highlights a critical gap that without clear protections and consistent messaging on genetic discrimination, uptake among at-risk family members is unlikely to improve. The Ministry of Health previously introduced a moratorium on genetic testing and insurance in October 2021. This policy was created to ensure that individuals are not discouraged from undergoing clinically indicated genetic testing or from participating in precision medicine research because of fears about insurability. This moratorium sets limits on how insurers can use genetic testing results and is meant to provide clear guidance and reassurance to both clinicians and the public on how the result can be utilized. Ultimately, its aim is to support access to genetic testing services without the worry of insurance consequences. I'm going to take some time and perhaps bore you on the details of the moratorium, which largely mirrors the one that exists in the UK now. Firstly, the moratorium differentiates between diagnostic and predictive testing. The formal definition of a diagnostic test in the document refers to a genetic test that can basically confirm or rule out a diagnosis. And under the moratorium, insurers are permitted to request disclosure of more types of diagnostic tests than predictive tests. And a genetic test is then considered predictive when it's able to predict a future risk of disease in individuals without symptoms or signs of a genetic disorder. At the end of the day, these definitions can be very confusing even to people in this space, and especially to the general public. It's important to note that many genetic tests can be both diagnostic and predictive, like for example, in hereditary breast and ovarian cancer testing. It is both predictive and diagnostic. You can have a diagnosis of HBOC without a cancer diagnosis. And under the moratorium, insurers are not allowed to request applicants to undertake any genetic test to obtain insurance coverage, be it diagnostic or predictive. Insurers are also not allowed to ask applicants to disclose and use the result of any predictive test to guide policy underwriting for any of the following types of insurers. So that basically means insurers cannot coerce any unaffected individuals to undergo genetic testing to purchase the following types of insurers, be it health insurance, which include integrated shield plans that are available in Singapore, general insurance, group insurance, and any other insurance types not covered or not outlined within the moratorium now. Under the moratorium, Insurers are also not allowed to ask applicants to disclose the following and to use the result of any of the following types of genetic testing. And that includes direct-to-consumer genetic tests, anything that was marketed to an individual without clinicians' input, a test done on another person. So for example, if an applicant is purchasing insurance, insurers cannot ask for the family member's result, or if the test was taken after the insurance coverage has started, or if the test was done as part of research. Insurers are allowed to request disclosure when the following 3 criteria are met. So the first of its kind, it's insurance type, when the insurance applied for is either life, total permanent disability, long-term care, critical illness, and disability income insurances. And the second criteria is the amount insured or the sum assured and the payout of the insurance applied for exceeds the financial limits specified in the moratorium. And the third criteria is the genetic test type. If the applicant has undergone a genetic test from the list of tests approved for disclosure under the moratorium, and for now it remains only for Huntington's disease tests and BRCA1 or 2 genetic tests. This table is included in the moratorium. It highlights the conditions that need to be met that permit the insurers access to the genetic test results. So for example, if an applicant is considering life insurance, okay, or total permanent disability insurance or type A long-term care insurance, and if they are looking at insurance that is in a value or above the financial limit that is listed over here in the moratorium. So for example, if I'm perhaps a Huntington's disease carrier looking to insure my life for $2 million, that would allow insurers to access that result. And then this is the one that refers to individuals who have a BRCA1 or 2 test. And I think it's be negative or positive, these results can be accessed by insurers. So if I'm a BRCA1 carrier, looking to take out a 500,000 value critical illness policy, I would be requested by my insurers to release that result, and that would then affect the policy underwriting process as well. So between 2021 and 2024, several efforts were taken by the team to help advance and refine the moratorium. First, we participated in an industry-wide engagement session, providing direct feedback to the ministry as well as the moratorium task force on the operational gaps, clinical implications, and concerns we were hearing from our patients. We also facilitated a patient engagement session with individuals who were BRCA1 and 2 carriers, and this with MOH, okay, so this allowed them to gather first-hand perspectives from those who were probably most affected from this moratorium, including their experiences, fears about insurance, and what protections will make a meaningful difference for them and their family members. However, on the 7th of November this year, the Ministry of Health announced updates to the moratorium with a specific focus on enhancing protections for individuals in the National Familial Hypercholesterolemia Genetic Testing Program. And under this updated policy, if someone has undergone genetic testing through the National FH program, insurers are now explicitly prohibited from requesting or using these genetic test results. But then those who did testing overseas or did testing outside of this national program could still have their results accessed by insurers. So while this is a significant step that strengthens protection for this patient group, it still does leave out a significant proportion of them as well. And it's also important to note that there were no additional protections that were introduced for BRCA1 or 2 carriers in this round of updates, and it remains an area where further policy development is still needed. So from our conversations with our patients, they have highlighted several ongoing problems related to insurance and genetic testing, which we are about to compile in an upcoming interview study. Some patients present to the clinic as they've been coerced into undergoing genetic testing by insurers, even when the test is not clinically indicated. Others report encountering new policy exclusions or raised premiums after disclosing their results. A number of patients have also shared that insurers have requested for family members' results despite the moratorium's intent to prevent such practices. Perhaps most concerning is we've heard of individuals who've tested negative for the familial variant, but they still have had their insurance premiums increased, simply suggesting that being from a family history that that has with a strong family history or prior suspicion of a genetic condition is sufficient to increase your insurance premiums. And these issues highlight gaps between policy and practice and underscore the need for clearer and more enforceable protections. We're also seeing several systemic issues that limit the effectiveness of the moratorium. Firstly, public awareness remains low. Many of our patients and the individuals of the public don't know that these protections exist. Engagement with policy providers have also been very limited, leading to inconsistent understanding and limitation across companies and providers. There are no clear regulations or enforcement mechanisms, so no penalties are in place if the moratorium is not upheld. There is also no feedback loop for the public to report their concerns or breaches to the moratorium that they experience. I think most importantly as well is that BRCA1 carriers, which are we do understand are more prevalent in our population, 1 in 150, will continue to face discrimination as these current protections within the moratorium do not adequately address their needs. And looking at how these are more prevalent in certain racial groups in Singapore, like Malays, it can also be seen as discrimination at a racial level. Together, these gaps show that the moratorium still requires stronger structure, communication, and accountability. Future work, and it really represents the work I hope to be achieving in the next 4 years while I embark on my PhD. The first stage focuses on exploring and documenting the patient perspectives of genetic discrimination and understanding the moratorium and their understanding of the moratorium through semi-structured interviews. Our second phase will focus on exploring stakeholder perspectives from policy planners, insurers, patients, healthcare professionals to inform the design of policy recommendations to address genetic discrimination using the technique called concept mapping. And lastly, we would then evaluate and refine these policy recommendations through a Delphi process with key stakeholders. We eventually hope to work with the ministry to eventually implement these recommendations that we come up with as well. So I've come to the end of my talk. Thank you so much for listening. Any advice on my study design or how to engage the right stakeholders for Singapore to progress in the right direction will be very much appreciated. Here are my contact details, and if there's time for questions, I'm happy to take some as well.
Great presentation. I have a quick question. I'm just curious about, because now you were talking about insurance, right? So I'm curious about how about genetic discrimination in employment in Singapore? You have any statistics or anything to
So
share
yeah,
with
we're
us?
just catching up with insurance. Employment is really still a way to go. I'm sure there's stuff happening on the ground, but no studies have been done on that. We're really just trudging along. From what my experience from speaking with my patients, generally, and when anyone starts a new role, they might go for a health screening, and they do have to declare certain conditions that they have. Some of them prefer not to disclose, because if it's not worded in a way where they need to disclose, they wouldn't disclose it. And sometimes some of my patients with genetic conditions, they also try not to take so much leave so that people don't know they have a genetic condition. So I do think that there is some form of employment discrimination going on, but it hasn't been officially studied yet.
Okay, very interesting, because from my research in China, genetic discrimination in health insurance or commercial insurance is not as reported that much. However, in employment, there are definitely some cases.
Yeah, I would agree. It's probably there, but we're just not looking into it yet. Yeah.
Thank you.
So I have a question which might actually help us understand the various types of discrimination. When insurers want to use genetic information, Jeanette, in your country, do they pass by the clinician or by the genetic counselor? So for example, for us in Canada, the way they used to do it when they could is that they would very often send in the application form directly to the hospital or to the clinician. and say, here's an application form for this person. As you can see, they signed that we can verify all their information. Please communicate to us all genetic test results. So we can have an idea of, how much the phenomenon is pervasive, and, where it's, what kind of information they're actually seeking, these sorts of things. So in your case, what you're saying is that they would ask directly the person that is applying for an insurance contract to communicate, so they put the burden on that person.
Yeah, it's more common for the insurers to ask the applicants for these results directly, because when you apply for insurance in Singapore, you go through a whole declaration process, and in that process, the insurers would then ask you for your results. I've looked at the insurance process and they do have a field that asks about genetic testing results. That's quite common in all the main providers. We do get that health screening report request as well. But when we receive that, that's when we actually check with the patients to see, what's going on. We usually do get a heads up from our patients as well, that these requests are coming. But that's really maybe about 5%, okay, of the problems we face. Most of it, they just pressure the applicants directly, because they're basically salesmen trying to get you to buy a policy, but they're also the most experienced and knowledgeable in this field. So a lot of patients actually defer to their insurance agents on what their coverage and what their rights are, what their coverage is. And so the lack of awareness of the moratorium and the protections in place is also can be quite disappointing, to know that these applicants can be taken advantage of simply because they don't know what their rights are. Yeah.
Right. And the ceiling, if I understand well the ceiling approach, so they only ask questions like that if it's over a certain ceiling?
That's the thing. They don't really follow that ceiling. We're seeing that the question about genetic testing comes about even if the ceiling wasn't reached. Yeah, it's just a general question that's part of that declaration form. Yeah.
Okay, so they basically say, trust us, we won't use it
Yeah,
unless
yeah. So
that's
say
for us
just
to.
tell us, and then so you can see, but you're not allowed to lie on the declaration form as well, because you have to declare that it's true. So just
Yeah.
having that question in there is actually very wrong. It's not allowed by the moratorium. So unless the applicant is buying, above the financial limit, but
Yeah, and it puts a big onus on you to disclose basically all of these
yeah.
information if you're the one doing the
Yeah.
the
So
informing.
no one's monitoring that process as well. So every provider has its own form. They word it differently. Yeah.
Okay, well, it's interesting because it shows that yes, a law would be great, but in the meantime, actually, there's a lot of things that you can work on as well,
Yeah.
including the information part, and
Yes.
maybe get some sense into your insurance community so that they at least stick to their own sort of terms in the meantime. I think there's some really interesting things you could do by, yes, engaging the community a little bit, and looking forward to talk to you more about some of these things. I'm sure we'll have the opportunity. Thanks again.
Yeah.
It's a great presentation and very interesting to see how things are moving in Singapore.